bei der Flammurschale von der Firma Focus Strategie. Wir haben den Mittwoch, den 19. Januar 2022. Press Release, The Hague, 29. November 1996. 29. November, das ist Dezember 11. 29. 29 November 1996, press release from the International Criminal Tribunal for the former Yugoslavia, an institution of the United Nations. The International Criminal Tribunal hands down its first sentence, 10 years of imprisonment for Drazen Erdemovic. So, the International Criminal Tribunal hands down its first sentence, "10 years of imprisonment for Drazen Erdemovic." Trial Chamber 1 of the International Criminal Tribunal for the former Yugoslavia handed down on Friday 29th of November 1996 the first sentence for a crime against humanity by an international court since the trials in Nuremberg and Tokyo. Presided over by Judge Claude Jorda and consisting of judges Elizabeth Odio Benito and Fuad Riyad. The chamber has sentenced the accused Drazen Erdemovic to imprisonment for a term of 10 years. At the hearing, which was held in public and in presence of the accused, the presiding judge read a summary of the decision. This summary is attached. So the summary. A summary of trial chamber judgment. The prosecutor versus Drazen Erdemovic. 29th of November 1996. In determining the appropriate sentence for Drazen Erdemovic, the trial chamber has based its judgment on a line of reasoning, in law and in fact, which it will now summarize in broad terms, recalling that the judgment in its entirety will be available to the public in the authentic version, in brackets, for example in French, close brackets, immediately after this hearing. The operative provisions of the judgment, including the sentence pronounced, will be read at the end of the summary. The accused being present in accordance with Rule 101 or 101 in brackets D, close brackets, of the Rules of Procedure and Evidence. The judgment delivered by the trial chamber is structured as follows. After setting out the historical background of the procedure, but before entering into its reasoning, the trial chamber believed it's necessary in this case to consider the validity of the accused's plea of guilty. It then outlined the legal framework of its jurisdiction, identifying the law and principles it deems applicable regarding crimes against humanity. Lastly, it analyzes the acts with which the accused is charged, in particular from the angle of the mitigating circumstances he invoked in his defense. Given the circumstances surrounding the guilty plea by Drazen Erdemovic, the trial chamber felt it incumbent for it, before proceeding to any consideration of substance, to review the validity of the plea. It first ensured that, as of his initial appearance before the trial chamber, Drazen Erdemovic pleaded guilty voluntarily and fully cognizant of the nature of the charge of its implications. The trial chamber considered in particular the psychological examinations it had itself ordered carried out. As justification for his conduct, however, the accused invoked the urgent necessity for him to obey his military superior and the physical and moral duress stemming from threats to his own life and the lives of his wife and child. The trial chamber could legitimately consider whether the elements put forward, which in themselves are such as to mitigate the penalty, might also, in the light of the probative value attributed to them, be regarded as factors justifying the criminal conduct and thereby affecting the very existence of the crime itself. The trial chamber would point out, first, that for an accused, the choice of pleading guilty is part of a defense strategy he is formally recognized as having within the procedure in force at the International Tribunal. That strategy has been fully and consciously adopted by the defense. In respect of superior orders, the only case envisaged in the statute, it does not relieve the accused of his criminal responsibility. At most, it may justify a mitigation of sentence if the tribunal deems it consistent with justice. As regards the physical and moral duress resulting from the superior order, and in the absence of any reference in the statute, the trial chamber has examined how the International Military Tribunal at Nuremberg and the International Military Courts delivering judgments after the Second World War had distinguished between exculpatory duress, which justified the crime, and duress as a grounds for a mitigation of sentence. While justification on account of moral duress and the state of necessity pursuant to an order from a superior may not be excluded absolutely, its conditions of application are especially strict. The acts invoked, if proven, must be assessed according to very rigorous criteria and appreciated in concreto, and involve in particular the lack of moral choice by the accused when placed in a situation where he could not resist. Exercising its unfettered discretion, the trial chamber has not hesitated to be particularly demanding, since the ambit of the International Tribunal is the prosecution of the most serious crimes of international humanitarian law. However, the elements drawn from the facts of the case and the hearing have not enabled the judges to consider that evidence warranting a full exculpation of the accused's responsibility exists. The elements invoked by the defense will accordingly be taken into account as mitigating circumstances. On this basis, the trial chamber confirmed the validity of the guilty plea. 1. Or first, applicable law and principles. Applicable law and principles. The sentence delivered in this case is the first sentence to be delivered by the International Tribunal and relates to crime against humanity. The trial chamber was therefore confronted with legal issues which it had to resolve before proceeding to the actual consideration of the gravity of the acts and the circumstances of the accused. In the logical order in which they are addressed, These issues are: 1. The scale of penalties applicable when an accused is found guilty of a crime against humanity. 2 or 2nd. The principles governing sentencing. 3 or 3rd. Enforcement of the sentence. So, and now it goes back to number 1. The scale of penalties applicable when an accused is found guilty of a crime against humanity. Under the statute and the rules, the International Tribunal may sentence an accused who has pleaded guilty or is found guilty to imprisonment only, which may be up for the remainder of his life. In addition to the reference to the general practice regarding prison sentences in the courts of the former Yugoslavia, which will be addressed below, the texts provide no indication as to the term of imprisonment incurred for a crime against humanity. The trial chamber has therefore identified the characteristics specific to such crimes and to the penalties attached thereto under international as well as national law. As stated at Nuremberg and recalled by the Security Council in its resolution establishing the International Tribunal, crimes against humanity refer to inhuman acts of extreme gravity. These crimes violate human beings in what is most essential to them. They transcend the individual, since through the assault on the latter, humanity is negated. And whether at Nuremberg, where the most severe sentences, in brackets, going as far as the death penalty, close brackets, were pronounced and executed, or within the domestic legislation of states that have introduced crimes against humanity therein, or within the relevant legislation of the former Yugoslavia, the harshest penalties have been laid down for crimes against humanity. It is the expression of a general principle of law recognized by all nations. As to recourse to the general practice regarding prison sentences in the courts of the former Yugoslavia, as referred to in the statute, the trial chamber notes that crimes against humanity are not strictly speaking found in the provisions of the Yugoslavian Code, which provides for in Anführungs- und Schlusszeichen, genocide and war crimes against the civilian population. The case law of the courts of the former Yugoslavia is hardly significant, in particular on account of the small number of judgments. Accordingly, the trial chamber considers that the general practice regarding prison sentences in the courts of the former Yugoslavia is not binding on it. The judges consider even that making recourse to that practice the sole standard for determining the scale of penalties would, owing to the principle nullum crimen nulla poena, sine lege, sometimes invoked, by tantamount to disregarding the criminal character that is universally attached to crimes against humanity, as such crimes have for a long time been part of the international legal order, and the harshest penalties attached to them. Consequently, the judges merely consulted that practice. Now we go to number 2, principles governing sentencing. The trial chamber identified in turn the factors enabling the penalty to be fitted to the case in point and the purpose and functions of the penalty. A. Factors enabling the penalty to be fitted to the case in point. According to the terms of the applicable texts, these factors are primarily the gravity of the offense, the personal circumstances of the accused, and the existence of aggravating or mitigating circumstances, including substantial cooperation of the accused with the prosecutor. The trial chamber has rejected the existence of any aggravating circumstances. Besides the fact that they are not defined in the rules, the trial chamber's position is that circumstances that might characterize the gravity of the crime may only cancel out any leniency based on mitigating circumstances. leniency, Nachsicht. The situation is wholly different as regards any mitigating circumstances. The statute and the rules provide non-restrictively for situations which, if proven, are such to lessen the degree of guilt of the accused and warrant a mitigated sentence. In this respect, the trial chamber takes account inter alia of remorse. As stated above, mitigation on account of superior orders alone is expressly enshrined in the statute, replicating on this point the statute of the Nuremberg Tribunal. The fact that an accused acted pursuant to superior orders was often raised before the international and the national military courts established after the Second World War. The Nuremberg Tribunal did not question the admissibility of superior orders for a mitigation of sentence, pointing out, however, that the order received by a soldier to kill or torture in violation of international law of war had never been regarded as justifying such acts of violence. A soldier could rely on it only to obtain a mitigation of punishment. The real test of criminal responsibility being by no means a question of the order received, but of the moral choice of the perpetrator of the act charged. Nonetheless, the trial chamber believes that dismissing the defense of superior orders, as was the practice of the Nuremberg Tribunal, was due to the high position of authority of the accused, and that, as a result, the precedent-setting value of the judgment in this regard is reduced in the case of an accused of low rank. In his report, the Secretary General of the United Nations addressed the issue of superior orders in connection with duress, considering that the order of a government of superior may be considered in connection with other defenses such as coercion or lack of moral choice. The trial chamber will content itself with that position provided the elements prone to characterize a state of necessity or duress as argued by the accused no more. Again, the trial chamber will content itself with that position provided the elements prone to characterize a state of necessity or duress as argued by the accused are proven by him. Lastly, given the tribunal's situation, which is exceptional because it does not have its own facility for imprisonment, the trial chamber takes note of the unavoidable isolation in which convicted persons serving their sentences in institutions often far removed from their place of origin will find themselves. It continues then with B, or perhaps I read it now and then in the next part I will split it up in two videos. In the next part you will hear 3 enforcement of the sentence, but I continue now with B. B. Purposes and functions of the penalty for a crime against humanity. Given the unique nature of the International Tribunal, the trial chamber shall consider the purposes and functions of the penalty for crimes against humanity, and more particularly a term of imprisonment. Neither the statute nor the report of the Secretary General nor the rules elaborate on the objectives sought by imposing such a sentence. Accordingly, to identify them, the focus must be on the very object and purpose of the International Tribunal. The trial chamber thereupon examined the purposes and functions of the penalty for a crime against humanity in the light of international criminal law and of national criminal systems, including that of the former Yugoslavia. As they emerge from the texts at the origin of the International Tribunal, the objectives as envisaged by the Security Council, for example, deterrence, reprobation, retribution, as well as collective reconciliation, are part of a broader aim of the Security Council to maintain peace and security in the former Yugoslavia. The only precedents in international criminal law, the Nuremberg and Tokyo tribunals, do not expressly state the purpose sought in imposing penalties for war crimes or crimes against humanity, but a review of the declarations by the signatories of the London Charter would indicate that the penalties seemed to be aimed at general deterrence and retribution. The purpose and functions of national criminal systems are often hard to identify precisely. They are multiple and have, moreover, been written to a large extent into the criminal code for the Federal Republic of Yugoslavia. The competence of the International Tribunal differs fundamentally from that of a national court, which punishes all sorts of offenses, usually ordinary crimes. In the light of the above review, the Tribunal Chamber deems most important the concepts of deterrence and retribution, but it would insist especially on reprobation as an appropriate purpose of punishment for a crime against humanity and the stigmatization of the underlying criminal conduct. Perhaps I should have written down the subtitle or the chapters. So we heard now 1 or 1.1. 1.1 is the scale of penalties. Applicable when an accused is found guilty of a crime against humanity. One point two, the principles governing sentencing.